Hingorani, Honorable Chief Justice of India, Shri T.S. Thakur, Honorable Dr. Justice Dalveer Bhandari of the ICJ, Ambassador Ashok Mukherjee, my dear friend M.K. Raina, and numerous distinguished people in the audience. This is really an honor for me to be present today at this discussion and launch of Dr. Hingorani's book. The book is remarkable in three respects, and I think it's important to underscore these separately. First, and I really hope all of you read the book, the print is rather small and it's very densely argued, but immensely rewarding for the way in which the author has marshaled facts of history and diplomacy, but also the way in which it is informed with a great deal of sensitivity about the Kashmir issue, the people of Kashmir, and dare I say, the nuances of the Indian constitutional tradition, which Dr. Hingorani insists must also play an important role in any quest for a solution to the Jammu and Kashmir issue. But the first area where it really breaks ground is that it fills a crucial gap in the international diplomatic political discourse on J&K as a so-called flashpoint, or J&K as a diplomatic problem, or J&K as an agenda item on the Security Council. Now, those of you who have followed the issue know that it is more or less a constant in the Pakistani position, although when Pakistan articulates that also depends on the state of its relations with India at any given moment in time. But it is a constant of the Pakistani position that there needs to be a plebiscite in Jammu and Kashmir under the auspices of the UN, and that the failure to hold such a plebiscite is entirely because of India, and that until such a plebiscite is held to ascertain the wishes of the people of J&K, there can be no settlement of the Kashmir issue. This has been a standard Pakistani position, echoed to varying degrees by people in Jammu and Kashmir who espouse the cause of Azadi or accession to Pakistan or separatism in any shape or form. Now, the response to this claim, the response to this argument on the importance or necessity of a plebiscite has traditionally come from the government of India in one of two ways. Less frequently heard is the narrow legal argument that even by the construction of relevant UN Security Council resolutions, a condition precedent to the holding of a plebiscite is that all Pakistani troops in the territory of the princely Indian state of Jammu and Kashmir must first vacate. They must first leave. And since Pakistan never did that, there can be no question of holding a plebiscite. This is, if you will, the narrower legal argument that is used less today. It's not given by the government of India anymore, but it's used in rhetorical arguments. The main argument of the government of India is that in essence, the wishes of the people of Jammu and Kashmir have been ascertained multiple times over by the conduct of elections in J&K, and that there is no further obligation that India has, not least after the agreement, the Shimla Agreement, where J&K became a bilateral issue, and the Indian position is that Jammu and Kashmir should cease being an issue of concern to the Security Council. Dr. Hingorani's book proposes, if you will, a unique answer to this traditional Pakistani position of why there needs to be a plebiscite. And it does so by essentially questioning the legal status of the UN Security Council resolutions themselves. Not only does it do that, it makes the even more difficult and challenging argument that to the extent to which the government of India and its representatives were party to a discussion and the eventual passage of resolutions at the UNSC, which called for a plebiscite, they actually had no legal or political authority or standing to do that. In a way, he argues that the UN resolutions on Kashmir are in some sense ultra-virus. The UN Charter, ultra-virus the India Independence Act, ultra-virus the Constitution of India. And since they have no legal standing, they have no basis to have been called into effect, any demand for a plebiscite based on that is untenable. This is in a nutshell, in a very crude form, the legal and political argument that this book makes. It's a novel and unique challenge. It's one that we haven't heard before. Certainly, I am unaware of this kind of an argument, and it is fleshed out with a great amount of detail, quite effective, and based on this argument, which is a central part of the book. Dr. Hingorani then goes on to construct what he thinks or what he argues is a possible solution out of the current impasse between India and Pakistan. And I think this is the first first manner in which this book breaks new ground. It is refreshing to read a book on Jammu and Kashmir, and I've read many, and all of you have read many, I'm sure, that actually raises a new point. Otherwise, we're always rehashing or recycling arguments that have been made in one way or the other, going back all the way to 1947. The second unique contribution that this book makes is in dismissing, quite correctly in my view, the possibility of any military solution to the Jammu-Kashmir issue, and also dismissing, not so robustly according to me, but that's his argument, the possibility of a political or a bilateral diplomatic settlement between India and Pakistan. Dr. Hingorani goes on to foreground the importance of international law as the subject matter or the arena in which the struggle or battle for a peaceful solution to the J&K issue can be found. This is again a new argument. Most Indians tend to shy away from looking at international laws offering solutions to problems that we face. This is, of course, with some exceptions. Early on in the life of the India-Pakistan bilateral dispute or diplomatic standoff, we did negotiate the Indus Water Treaty, which created the instrumentalities for international arbitration, and we recently saw judgments produced by international arbitration which have not been entirely to our disfavor. India has also embraced the International Tribunal for the Law of the Sea and its permanent court of arbitration, or the arbitral tribunal that comes out of it, to resolve, for example, the maritime boundary between India and Bangladesh, a settlement that incidentally did not entirely go to India's favor, but which India has embraced as a valid and fair settlement. So there are examples where India has embraced international law and its instrumentalities and tried to make use of them to find solutions to difficult problems. When the Rome Statute for the International Criminal Court was being negotiated, and I'm sure Mr. Mukherjee knows everything about this, but one of the issues that India tried to raise at Rome was that if we are going to create an international criminal court, then it should also address the crime of terrorism. And when the ICC, when negotiating parties chose not to include terrorism as one of the crimes that would be covered by the ICC, this became one of the reasons why India decided not to participate or to sign up to the Rome Statute. There are, of course, other reasons why we chose to keep off it. But one could see in the what lawyers call the working papers or the travaux préparatoires of the Rome Statute, an attempt by India to see if we can work the instrumentalities of international law or international criminal law in this case to get a better grip on or to find a solution to the problem of Pakistan-sponsored terrorism that we were confronting. The ICJ is mentioned in some detail by Dr. Hingorani as the venue which could produce a solution. We've had limited experience with the ICJ. Dr. Hingorani mentions the Atlantic case, where Pakistan took India to the International Court of Justice at The Hague. for the shooting down of a Pakistani Air Force plane that they claimed happened over Pakistani airspace. We said it was over India. But in any case, we did not accept the jurisdiction of the ICJ because, the ICJ found in our favor on procedural grounds. But ICJ is also a mixed bag. One could argue that some of its findings, some of its judgments, for example, in the nuclear weapons case, the ICJ, having found that the use of nuclear weapons would constitute a crime against humanity, somehow balked at taking that ultimate step and declaring that even the possession of nuclear weapons, because these are after all possessed by states in order to use them, would also constitute a similar crime against humanity. That was a politically sensitive judgment that the ICJ chose not to make. And there are many other examples where the ICJ has pulled back, essentially reflecting at one level the politicized nature of international law, particularly at that apex level. But India has had some experience with international legal institutions, and Dr. Hingorani makes a convincing, passionate case for foregrounding international law in seeking a settlement to the Jammu-Kashmir issue with Pakistan. How he does that is explained in the book, but essentially he makes the case that we should seek a determination from the ICJ. And of course, because of the nature of Pakistan accepting the compulsory jurisdiction of the ICJ, Pakistan will have to go along with this. And the burden of the case that Dr. Hingorani wants India to present to the ICJ is essentially to question the validity of UN resolutions on Kashmir, and even any assurances that India or its representatives may have given that we would also take into account the wishes of the people of Jammu and Kashmir in deciding the accession of J&K, that the decision of the sovereign ruler of Jammu and Kashmir was not enough. And Dr. Hingorani argues how under the India Independence Act, in fact, the decision of the sovereign was enough, and that there was no reason whatsoever and certainly no legal validity to any of the promises or assurances that the government of India might have made subsequently. And essentially, it is his hope that a robustly argued case before the ICJ declaring these resolutions invalid and will then lead to the next step, which is that the possession of Jammu and Kashmir territory by China and Pakistan is also illegal and has to be vacated, and that out of this kind of a ruling, a solution might emerge which would restore Indian territory to India that no amount of diplomacy would succeed in producing. The third area where this book breaks ground, and he doesn't devote as much space to it because clearly the focus of the book is on the international law questions. But there is a very useful chapter or section on the place of repressive legislation in India. And Dr. Hingorani makes a very convincing argument about why TADA, POTA, AFSPA, the Armed Forces Special Powers Act, particularly Section 4 of the Armed Forces Special Powers Act, which is actually ultra-vires the Indian Constitution. He finds fault with the Indian Supreme Court in not going the whole hog, in appreciating the ultra-vires nature of the Armed Forces Special Powers Act. He might have added that the jurisprudence that we have seen, or the cases that we have seen that have come up to the Supreme Court concerning the Armed Forces Special Powers Act have produced perversities that do not help in the quest for a solution. I will mention one of them. It's not in the book, but I would flag it for you, which is the Patribal fake encounter case, which is a case going back to 2000, when the Rashtriya Rifles and the Jammu Kashmir Police, on the basis of an FIR, admitted to killing 5 people. Subsequently, these people were proved to be civilians, and there is today no dispute about the fact that those 5 dead people were civilians. There is no dispute about who killed them because the army and the police filed an FIR saying that we killed these guys. The matter hung fire for several years because the army said the police have no right to investigate this because we have to first give permission, which we are not going to give. And finally, the matter ended up with the CBI. The CBI filed a charge sheet indicting army officers and soldiers of murder under 302. The court, this matter again is litigated all the way to the Supreme Court, where the Supreme Court finally says to the army, gives them an ultimatum, that you either prosecute these men yourself or subject yourself to a civilian court. Now, the Supreme Court should have connected the dots and seen how an army which has refused to prosecute for 15 years, if given the chance to prosecute, is likely to exonerate. And that's precisely what happened. Before a court-martial could even be held, the army decided there was no evidence. And what happened finally is that a case where the identity of the dead people is not in dispute, the identity of the killers is not in dispute, and the CBI, as a professional investigating body, had filed a charge sheet for murder. The army says there's no evidence, and the victims of this crime receive no justice. In my view, no matter how much we lean on international law, no matter how much we make a strong case diplomatically and legally in international forums, if the Indian state and its instrumentalities are unable to deliver justice to the people of Jammu and Kashmir, which is an integral part of India, and as people who are living in an integral part of India, they deserve the same access to justice as other citizens of India. If Indian institutions are unable to do that, and this is what Dr. Hingorani hints at in his critique of some of these laws, then a solution in some sense will also prove to be elusive. My last point, I do want to present my 30-second evaluation of a solution. It's a bold solution. ICJ, going to the ICJ, how practical that is something which legal experts and international lawyers will have to debate. My sense is that given the appetite of our political class and given the appetite of our bureaucracy, this is likely to be a bridge too far. Perhaps one obstacle, let's see how the ITLOS, the Enrica Lexi case, which is proceeding right now on merits, the shooting of two Kerala fishermen, which is now before a arbitral tribunal of the International Law of the Seas Tribunal, how that proceeds. If India does not get justice out of that, if the two Kerala fishermen, if the arbitral tribunal finds in Italy's favor, in a case which to my mind seems open and shut, and to many Indians seems open and shut, that would probably weaken the case that Dr. Hingorani has built in his book of relying on international courts for justice in some of these complex issues. But I will leave you with the final thought, which is whether India and the Indian state is paying enough attention to international law as a subject. You just have to, if you look at the litigation ongoing at the arbitral tribunal, the battery of Italian lawyers, specialists in international law, who accompany the Italian agent in the hearings before the arbitral tribunal, you see, and you compare that to the Indian situation, where you have a few bureaucrats, the Indian ambassador, the same highly competent Dr. Neelu Chadda, who used to head the Legal and Treaties Division, is the Indian agent for the Enrica Lexi case. She is also the Indian agent for the ongoing Marshall Islands litigation at the ICJ. There is a fact that the Indian government has not paid enough attention to creating a large enough cadre of specialists who understand and are familiar with international law, and perhaps works like Dr. Hingorani, by foregrounding the importance of international law in settling complex political disputes, will serve as a reminder. Even if they don't change state policy, they will at least serve as a reminder for the important role that international law must play in a large country like India, which aspires to a global role, which aspires to a major role in all important international issues, that we cannot get by and we cannot play that role if we're going to produce only a handful of international lawyers, most of whom are going to be working for the government. If there isn't seamless use by the MEA or by other government ministries of the international law expertise that you have in universities, unless there is greater interaction of that kind, I'm afraid the full potential of international law as something that India can harness in its favor will never be realized. Thank you very much.